A very good afternoon to everyone who has joined us today for this webinar. And I am delighted to welcome Professor Dr. Bharti Kumar to the session. She is a professor of National Law University, Delhi, and has joined the institute in 2009, prior to which she was teaching in the Faculty of Law at Delhi University from 1998. Her areas of interest and specialization are environmental laws, human rights, humanitarian and refugee law, constitutional law, laws relating to women and ADR, etc. She is involved in teaching of clinic papers pertaining to legal aid, court management, and professional ethics. She is also the director of Center for Environmental Law, Policy and Research, NLUD, that has conducted various initiatives on environment, including teachers training program on environmental laws, and has initiated 2 online PG diploma environmental law courses recently. She has also presented various papers on different themes, including Sark law, Bhutan, and GAJE at Turkey. She has been a part of Law Commission's panel on early childhood development as well as NCT CR's panel on education, child marriage, etc. She has also been actively coordinating legal aid activities and workshops in NLU Delhi. It is an immense pleasure to have you in this session, ma'am.
For your address on this very important area. When we look at the Constitution of India, that's really the touchstone of any kind of law. And, in order to understand whether the law is correct, valid, invalid, what kind of challenges it may face, in a court of law. So the opening words of the Constitution and the preamble, that India is a sovereign, socialist, secular, democratic republic, I think they are very, very meaningful, because the word democratic, as also Sir pointed out, it's one of the bedrocks of the Indian Constitution. And we have adopted the parliamentary system of, governance. And in that respect, representative form of democracy, where elections play a very crucial role. And they really become the, the kind of the main way in which the voice or the opinion of the electorate is incorporated. So the growth of the Indian Constitution has been a very organic one, and it has stood the test of time. And in fact, at this present point of time, where there are so many amendments that have been made, and the basic, the kind of formulation of the Indian Constitution, it remains as it is, with, of course, so many modifications that have come up. Now, Article 239 AA, which came up in 1991, it really set at ease, or it really kind of pronounced the legal framework within which the Union Territory of Delhi was really to work in. The kind of, the whole issue of the LG and the elected government was attempted to be addressed there. And then we find the next important, milestone came in the form of the Act itself of the the Government of National Capital Territory of Delhi Act of 1991, which further attempted to streamline various issues. And I would just like to give you the kind of the introduction to that Act of 1991. An act of supplement to the provisions of the Constitution relating to the Legislative Assembly and a Council of Ministers for the National Capital Territory of Delhi, and for matters connected therewith or incidental thereto. So it is a supplemental act. And a supplemental act cannot go beyond the parent or the constitutional scheme of things. So it has basically kind of filled in the details. And in this act, we find there is particularly section 441, which is, I think, of relevance for the present topic that we're doing. I'll just highlight it. Just a minute. So, yeah. So Section 41 speaks about matters in which the Lieutenant Governor can act in discretion. So, the Lieutenant Governor shall act in his discretion in a matter which falls outside the purview of the powers conferred on the Legislative Assembly, but in respect to which powers or functions are entrusted or delegated to him by the President, or in which he is required by or under any law to act in his discretion or to exercise any judicial functions. So there is a lot of possibility of discretionary power which is already existing with the Lieutenant Governor, and the next kind of change came in the Supreme Court judgment of 2018, in which there were 3-4 important areas in which the Supreme Court gave its very meaningful, very significant, the conclusions. Firstly, it said that yes, Delhi is not a state per se, but has a special status, and it is a sui generis status. And the governor, the lieutenant governor, is the administrator for the for Delhi in that sense. Then the lieutenant governor is not to act on his own, but is to act on the aid and advice of the Council of Ministers. And in fact, this aid and advice is given in Article 239AA itself of the Constitution. And I think this is a very, it says here particularly, if I'm just to read clause 4, there shall be a council of ministers consisting of not more than 10% of the total number of members and so on, to aid and advise the lieutenant governor, right? Except insofar as he is by or under any law required to act in his discretion. So that kind of links, Article 239AA and what I just before talked of Article, Section 41 of the 1991 enactment, that yes, the lieutenant governor has, he's to act on the aid and advice of the Council of Ministers, and he has certain room for discretion. And we are aware of those areas, where discretion may arise, especially when the assembly, dissolves, it loses its majority, and, it is subject to dissolution, and a successive leader has to be chosen from the existing set of parties that are represented in the Legislative Assembly. Of course, there are other matters of discretion also. For instance, in case of breakdown of constitutional machinery, then President's rule may be referred to. There is also the possibility of coming up with ordinances when the Legislative Assembly is not in session. And then, of course, you find that the LG has the delegated authority on the 3 subjects of land, of law and order, and of police, right? So these are the 3 areas that are accepted. These are exclusions, and they are well defined in Article 239AA itself. So this is, so the SC, the Supreme Court judgment in 2018, it emphasized adequately that the lieutenant governor was to act on the aid and advice of the Council of Ministers. In fact, a lot of emphasis was also given on the areas of cooperative federalism and representative government. These 2 phrases were used by the court, and again, they kind of highlight the legacy that the constitutional legacy that is there in present circumstances, and that we must not lose sight of. These representative government and cooperative federalism, although we are not having a pure federalism, but it is a very, it's again a very important part of the Indian Constitution, and the union of states and union territories that are existing. Yes, there are those checks and balances that remain, which provide for unitary features in case of emergencies and so on. But they must, it is a cooperative structure, and it must not be impinged upon as much as possible. The other area the Supreme Court judgment reflected upon was that the lieutenant governor, even the lieutenant governor also has the discretion to refer certain matters to the president, by way of in case of the legislative issues that arise and there are bills that are to be made into acts. So these can also be referred to the president. But here also the Supreme Court added a word of caution that lieutenant governor cannot refer every matter to the president. It must be a matter of last resort. And then finally, the separation of powers, which was talked about, that when we talk about separation of powers is again an integral concept which we have borrowed, from the Montesquieu's scheme of things. And in the Indian scenario, the separation of powers does not act as a regimented kind of a divide between the three branches of government, which is the executive, legislature, and judiciary. In fact, you would find that because of the parliamentary system that we have adopted, firstly, there is one particular aspect that must be kept in mind, that there is coextensive executive and legislative powers both at the center and at the state level. And this is adequately, it is reflected in Article 73 and Article 162 of the Constitution. So there are these powers which even in the kind of the situation of the National Capital Territory of Delhi, the state assembly is already existing and it exercises legislative power, and so the elected state government, by virtue of coextensive powers, should, in the ordinary scheme of things, exercise executive power. And the kind of so separation of powers, as a concept, is certainly applicable in the Indian system, but it is, there are those, again, the kind of the checks and balances that really become a part of constitutionalism and provide for a kind of integral idea of the center and the states as we understand. So now, finally, I would just say that when we're looking at the changes that are brought by this new enactment, the amendment to the 1991 Act, it attempts firstly that, of course, there are very massive changes, and it intends to enhance the power of the lieutenant governor and limit very strongly, in fact, the powers of the elected government. And it really confines it to a very subsidiary status. So, and this affects the chances of the people to really govern themselves, which is the requirement of a parliamentary democracy that we have adopted formally for ourselves. So essentially, the government, it is said to mean under this new enactment, it shall mean the lieutenant governor. And, in the words of, we have so many legal luminaries, and so many have expressed their dissent, with the various provisions of the will of this particular act. And particularly this provision where the government shall mean the lieutenant governor, it's a very imposing kind of provision which goes far beyond the kind of normal canons of democratic governance. So it is never, in the, lieutenant governor, government means the lieutenant governor. It is, in a very extreme kind of a manner that this is projected. Then secondly, you find that the other provisions where the rules, the rules of the procedure of the assembly can be made only in accordance with the rules of the Lok Sabha. This is again an objectionable portion because it is not conducive, rather, that with the canons of democratic understanding, because rules are inherent to every state assembly, the making of rules, and it is an inherent part of the work of the state assembly, and it is an original power, and it cannot be in any way dictated in accordance with certain rules that are made. Even, I mean, the rules of all state assemblies, they may be converging to some extent, but they are also very, very, original. The other part is that inquiries may not be conducted by the assembly. Now, this is again a very worrisome aspect, because in the day-to-day governance, there could be any kind of inquiry that may be needed. For instance, the health situation in any part of the state of Delhi in the given pandemic, if suppose it is deteriorating, an inquiry may be needed, for that purpose. So it does not permit the inquiry made by assembly into various administrative issues. The assent to bills, as has been, I think all of us are familiar, certain bills can be reserved for the consideration of the president, but now the kind of volume or the nature, or it can be any kind of bill can be referred. There was certain kinds of bills only that could be reserved for the purpose in the earlier situation. The LG's opinion on executive actions is now made a necessary component of, again, the day-to-day functioning, and the words which are so often used, that it would really result in so much of conflict, confrontation, literal paralysis of the governance. It all these naysayers, they seem to be, yes, there is a huge possibility of, in such kind of a scheme of things, where things would not be at all conducive for the smooth functioning of the government. So in the ultimate analysis, what we look at is at a situation where the bill has, and the most interesting part is that in the introduction, in the statement of objects and reasons, it has been said that the act is there to promote harmonious relationship between the executive and legislature, and further define the responsibilities of the elected government and the LG in line with the constitutional scheme of governance of the National Capital Territory of Delhi, as interpreted by the Honorable Supreme Court. So this kind of introduction to the act is totally in opposition, actually, to what the Supreme Court said earlier. So instead of, in fact, attempting, the constitutional, the provision which is present, Article 239 AA, that is, that was also introduced by way of amendment. So instead of really, effecting a further amendment to that particular article, what has been attempted right now is a legislative exercise which affects the foundation of that article itself. So, we are, the constitutional, say, kind of the when we are looking at the legislation and the constitutional the parameters, they are being infringed, and there is absolutely there's a likelihood of a challenge in a court of law, which is going to be difficult for the center to sustain the bill in view of so many objections that are going to spring up. So so when you're looking at the Indian democracy and the polity, there are so many, political, actually, the kind of confabulations which result in, really affecting the constitutional parameters, the constitutional fountainhead. And it is, what should be really attempted is that we try to keep the constitution in the forefront, and then we attempt whatever changes are needed, for the legislative purposes. But here we are trying to overhaul the constitutional mandate of 239 AA through a legislative measure. So this is extremely confrontationist, and it will not be sustained. It might not sustain in a court of law. So thank you so much for your patience and hearing. Yeah, I just like to add here that apart from the deep complexities of the political kind, what is very important, because everything we have to, it's not like we that all the challenges come in a court of law, right? So, and I think all of us would agree that there are basic, drawbacks in this bill, in this act rather now, which really infringe the constitutional provisions themselves. So, since for us the constitution is paramount, it is the will of the people, which is the and the constitutional supremacy and the the supremacy of the people. So it is going to be on that basis that the challenges need to be spelled out more clearly. And I think there is enough of reasons, for which uh, the bill may not be able to stand the test of, the various constitutional requirements in a court of law. So, yeah, thank you.
Thank you so much, ma'am.